So today we are having my sister, Sarah Teich, speaking to us about international law and more specifically how to hold states accountable for potential breaches in international law. She'll be using COVID as a case study, and she'll be probably referring mostly to her recent publication, which was called Not Immune, Exploring Liability of Authoritarian Regimes for COVID-19 Pandemic and Its Cover-Up, which I sent you guys in advance if you wanted to take a look. But yeah, Sarah has her Juris Doctor from U of T. She did her master's here in Israel at IDC Herzliya in counterterrorism. And she is a senior fellow at the Macdonald-Laurier Institute based out of Ottawa. She's a legal advisor to the Canadian Security Research Group and the Canadian Coalition Against Terror, CCAT. I don't know if there's anything else I should be adding. Maybe Sarah can jump in and start. I don't want to take any of her time either.
Thanks, Mir. Thanks for the introduction, and thanks to you all for having me. I am going to jump right in because I have a lot of information to share with you guys today. So how can I share my screen, Mir? Do you have to make me a host?
Yeah, hold on, working on it. Make co-host. Yeah, okay.
Great.
Should be okay.
Okay. Okay, can you guys all see this PowerPoint now?
Yep.
Okay. So today I'm going to be talking, as Miri said, about violations of international law and what to do about them. Now I want to say at the outset also, this is a pretty small class. I hear 20 to 30 people. So if anyone has questions at any time, please feel free to just unmute and ask me anything. Okay. So, I'm actually going to start with my conclusion slide real quick. Okay, because this is basically what I'm hoping you guys take away from this class. This is what I do in my day-to-day job. I have a client come to me and they say, hey, Sarah, what can we do about X? X being, what can we do about the Uyghur genocide? What can we do about ongoing human rights violations in Venezuela or Sri Lanka? Or what can we do about, China's concealment of critical health data in the early days of COVID-19? And my answer basically follows the same structure in terms of what analysis I go through. The first question I ask myself is this actually a breach of international law? Something can be ethically or morally wrong, but it's not necessarily in breach of a state's international legal obligations. So that's the first question. And then the second question becomes, okay, say it is, what can we actually do about it? Right, now I'm going to go back to the beginning. Hold on. Should have just copy pasted that slide. So I'm going to start with some fundamentals. I know you guys probably know all of this stuff in terms of sources of law, but just want to make sure we're all on the same page about it. So I'm going to start with sources of law and then some basics about international human rights law and international criminal law, some basics about human rights bodies, the ICC, the ICJ, some stuff in domestic arenas. And I'm going to actually spend the bulk of my time here on point number 4, because I do believe a case study is the best way to learn. And I did write about this recently, as Mary said, and we're going to look at China's concealment of critical health data as a way of analyzing basically all of the above. All right, so what are violations of international law? What is international law? I know you guys know these 4 sources: treaties, customary international law, general principles of law, and judicial decisions and scholarly work. The only 2 I actually care about for purposes of this lecture are the first 2. And the only real thing I want you guys to remember here is that treaties are binding on the states that sign them, whereas customary international law is binding on everybody. International human rights law. There are 9 core international human rights treaties today. These are them. I'm not going to bother reading them all out loud. You guys are going to have these slides. I'll send them to Miri after I'm done. The one that's going to be relevant for the COVID case study is number 3, International Covenant on Economic, Social, and Cultural Rights. And if you want to learn more about any of these treaties, I highly recommend the website of the High Commissioner for Human Rights. Now, remember how I talked about step 1 and step 2 just a couple minutes ago? Well, this is where it comes in handy. So the first thing I generally do if a client comes to me and says, hey, Sarah, what do we do about X? Is I look at the 9 core international human rights treaties and I see if one of them applies, and I see if the relevant state is a state party to one of those treaties. Now, if they're not, I look at, is there a customary international law prohibition? Maybe I should go over that a little bit in more detail. I do know you guys learned that in your international law course, but basically in a nutshell, customary international law is established when states persistently engage in a behavior or don't engage in a behavior because they believe that it's an international legal obligation. And then just Kogan's norms are norms that are so fundamental to the international legal order that states, it doesn't matter if states object from them, they're bound by them anyway. They're norms from which no derogation is permitted. And those are piracy, slavery, genocide, crimes against humanity, war crimes, and torture. So if there's no treaty that binds the party, you ask, okay, is there a customary international law prohibition? And then you ask, okay, if there is the state I'm looking at a persistent objector such that they're accepted from that norm? But then even if they are, is it a just Kogan's norm? So, if a client comes to me and says, hey, Sarah, what do we do about the Uyghur genocide? This whole analysis is basically short-circuited because genocide is a just Kogan's norm. So it's an international legal violation. Does this make sense so far? Does anyone have any questions? Okay. Maybe I'll open the chat box just in case someone wants to write a question. How do I do that?
I have a question already. Sorry, I'll turn my mic.
Yes,
how
please.
do you, in that, let's say with China, who defines if it's a genocide or not? Or has
That's a great question. It's a great question. So genocide is defined in the UN Genocide Convention. I wish I had time to go over that in more detail. Basically, genocide is if the state with intent to destroy in whole or in part a population engages in one of 4 behaviors. One of them is forced sterilization or other measures to infringe the birth rate. So that's where in the Uyghur genocide, for example, which is something I'm working on right now, that's a main factor. There's a major report that came out recently out of I think it was the Jamestown Foundation that analyzed birth rates and made a very compelling case for that in the case of the Uyghurs. Any other questions? Okay, let me open the chat box. How do I do that? Hold on. There it is. Okay. So international criminal law. I'll go into this a lot more detail when we talk about COVID. But basically, the Rome Statute of the International Criminal Court is interesting because it's a treaty that criminalizes just Kogan's norm. So this is, an example of how these two things can interplay, and it deals with genocide, war crimes, and crimes against humanity. Those are the 3 crimes that the court is entitled to look at. There's actually a 4th crime now of aggression, but that's complicated jurisdictionally, so I chose to exclude it from this PowerPoint. Now, the UN human rights bodies. These are important to know because if there's a breach of any of the 9 core human rights treaties, these are generally the 3 options that you look at. The first one is human rights treaty bodies. I'm actually going to go back a second to my 9 core slides. So for each of these 9 core human rights treaties, there's a UN treaty body that's responsible for overseeing compliance with it of the state parties. And also, this treaty body is put out general comments, which serve to clarify the precise nature of the obligations. So for example, going back to the ICSCR, because it is the one we'll end up talking about today, the human rights treaty body that's responsible for overseeing compliance of that is called the Committee on Economic, Social, and Cultural Rights, the CESCR. International law loves their abbreviations. The second general option here is special rapporteurs. There's something like 44, I believe. Most are thematic, some are country specific. So for example, you have a special rapporteur that's specifically charged with looking at human rights violations in Iran. There's also one for health. There's one for just about everything. And those are international human rights law experts that liaise with governments, put out reports, and generally any one country or individual can lodge a complaint with one of them. Third, you have the UN Human Rights Council, which similarly anyone can complain to, always sort of an option. Whether or not it's effective, the thing with all 3 of these human rights bodies, generally speaking, is that they're more about naming and shaming. They can't really do all that much. International law is essentially consent-based, especially when it comes to international human rights law. And these three options don't have a whole lot of teeth compared to some of the other ones we're going to look at today. Any questions or comments so far? Okay. So the ICC. So the ICC generally looks at, genocide, war crimes, crimes against humanity. The major limitation becomes, is the country in question a state party? For example, China's not, the US is not, Israel's not. So if the court wants to look at a particular case against one of those countries, it really needs a Security Council referral or some type of creative solution. So the case of Myanmar is a really great example of that. In this case, the court was looking at the alleged deportation or forcible transfer of Rohingya people from Myanmar, not a state party, to Bangladesh, a state party. And the prosecutor argued that because one of the elements of the crime occurred on the territory of a state party, Bangladesh, the court should be able to hear the case. And the court actually agreed. And these are some quotes basically saying just that. This is out of the pretrial chamber's judgment. They found that the court can assert jurisdiction if at least one element of the crime was committed on the territory of the state party. And particularly, it was the inherently transboundary nature of the crime of deportation that further confirms this interpretation. So, the Rohingya people, there's also allegations of genocide there, but that may not get before the court because it's not a transboundary type of offense, but deportation, could be a way in, sort of like getting a mafioso on tax evasion. But any questions before I move on of the ICC? All right. So the ICJ is another major international court. I know you guys know about this too. The ICC allows the international system to prosecute individuals who are alleged to have committed these sorts of crimes. The ICJ governs disputes between states. It requires consent. No country can be legally bound by a judgment unless they agree to be bound by a judgment. The exception is asking for an advisory opinion. So qualified UN bodies like the General Assembly are allowed to ask the ICJ to put out an opinion on a particular legal issue. And then that sort of gets around it. They're not bound by that opinion, but it is a way, again, of, serving up some pressure. Questions? All right, I'm gonna stop asking questions, just jump in with questions. All right, domestic arena. So it's sort of a common misconception that international law violations, you look at international institutions and that's it. But actually, there are really interesting domestic ways of addressing international legal violations. Major one is imposing sanctions. There's domestic legislation. Yeah? Someone have a question? No? Maybe that was just a background noise. All right, so there's domestic legislation that allows for sanctions on foreign officials, and then there's domestic legislation that allows for sanctions on foreign states. Now here, I'm really gonna talk only about Canada and the US because that's my particular specialty. And disclaimer, I'm not a US bar attorney. I've just done a lot of research on US law on this issue for my research report on COVID. So in terms of sanctions on foreign officials, these acts are called the Magnitsky Acts. There's a Magnitsky Act in Canada, there's one in the US, there's also one in the EU, and there's one in the UK. And they basically just all allow for those countries to sanction foreign officials that are involved in violations of human rights and or corruption. In terms of imposing sanctions on foreign states, the domestic legislation, at least between Canada and the US, is different. The Special Economic Measures Act, SEMA, in Canada allows for the Canadian government to impose sanctions on a foreign state if they engage in a violation of international peace and security, gross and systematic human rights violations, corruption, or the fourth option, which I didn't include on this slide, but will be on a later slide, if an international organization of which Canada is a member, like the UN, asks us to. For the US, the International Emergency Economic Powers Act, in keeping with generally how the US is a lot more broad. And basically, the US president can impose sanctions on foreign states as long as there's a national emergency and there's an international crisis. Pretty broad requirements. Any questions so far? I know I said I'd stop asking you that, but I just want to make sure everyone actually feels comfortable to ask me questions. I'm throwing a lot of information at you all. All right, civil lawsuits. Another thing you generally want to ask is, can my country, let's go with Canada here, sue a foreign state in domestic court? And the huge advantage of this is that if a Canadian court, for example, finds a foreign state is culpable for a violation of international law, then that country's assets can potentially be seized, sold, and have the proceeds can be distributed to victims. So it actually has a concrete result. Unfortunately, the general rule is that states are immune from civil lawsuits. And the only way to really get this is if you fall under one of the exceptions. I've listed here the 3 most commonly used ones: personal injury, terrorism, and commercial activity. Tort is just a fancy way of saying injury in legal speak. Personal injury means that if, for example, the government of Iran, because they don't like my research maybe, tortures me, then I can sue Iran in Canadian court. The difficulty potentially is that I can only actually sue Iran in Canadian court if Iran tortured me in Canada. Not that likely. So if Iran tortures me in Iran, a little more likely, then I can't come back home and sue Iran in Canadian court. So in practice, this exception is actually pretty restrictive. Terrorism simply just means that a foreign state can be held accountable in domestic courts for its sponsorship of terrorism. Commercial activity, also simple. A foreign state can be held liable for its commercial activity. And the philosophy behind this one is fairly simple. If the state is engaging in commercial activity, in that instance, it's not really acting like a state, it's acting like a private actor. So why should they be immune from jurisdiction is sort of the rationale behind that. Any questions here? Okay. Criminal prosecution. So as I said, the ICC is responsible for genocide, war crimes, and crimes against humanity. They have jurisdiction over those crimes. They're not the only court that has jurisdiction over those crimes. There's a principle called universal jurisdiction. And this just means that these crimes can be tried basically anywhere. So a Canadian criminal court can prosecute a foreign official if there's allegations of genocide, war crimes, or crimes against humanity. The specific requirements of that are contained in the Canadian domestic legislation that implemented this principle. And so, because it's tied to domestic legislation, as it is everywhere, how universal jurisdiction actually works depends a bit on each country. But basically, the foreign official would have to visit Canada. So it's not necessarily all that useful, but something to keep in mind. And then another complicating factor becomes personal and material immunity. This type of immunity is different than the state immunity for civil lawsuits that I just talked about. I'm talking now about personal and material immunity for criminal prosecutions. And this basically just means that heads of state, Minister of Foreign Affairs, and ambassadors and diplomats cannot be prosecuted criminally for anything they do at any time. That's personal immunity. It applies specifically to this very small subset of foreign officials. And material immunity means that, you or I, even if we engage in an official act for the state, we can't be criminally prosecuted for that. So that covers anyone who engages in official acts. That's material immunity. Material immunity isn't actually relevant for this discussion. I just included it for completeness because material immunity cannot cover genocide, war crimes, and crimes against humanity. It's a really old international law case that basically said that these crimes, genocide, war crimes, crimes against humanity, cannot be official acts for purposes of immunity. So really the only complicating factor here actually is personal immunity. Any questions? All right, now we're gonna look at the case study, COVID, specifically allegations that China concealed critical health information. So remember there's step 1. So is this a violation of international law? The answer is yes. It's a violation of the human right to health. This is in one of the 9 core human rights treaties, the ICESCR. Specifically, the human right to health is contained in Article 12. I'll go over this in more detail. It's also a violation of the international health regulations. It may be a violation of the Rome Statute. And it's likely a violation of the Biological Weapons Convention. As you could probably tell from my language, there's different levels of certainty here, but pretty certainly, assuming that the allegations are true, this would be a violation of the human right to health and the international health regulations. So I'm going to go over these first. So the right to health is contained, as I said, in Article 12 of the ICESCR. And this specifically obligates state parties to take steps to prevent, treat, and control epidemic diseases. China is a state party to the ICESCR, so they are bound by these articles. Now, interestingly, the right to health is also customary international law, so it would be binding on them anyway. But this just makes the whole analysis a whole lot simpler. Now, remember how we talked about the human rights treaty bodies, right? So the CESCR is the treaty body that monitors the ICESCR. And they also put out a clarifying comment to articulate the precise obligations that are contained in the right to health. And these are them: to prevent, treat, and control epidemic and endemic diseases. B is really important: to refrain from censoring, withholding, or intentionally misrepresenting health-related information. So we can almost stop there. It's a breach of the right to health, right? To provide education and access to information, similar information, to refrain from using or testing weapons. E is also really interesting: to refrain from limiting access to health services as a punitive measure. There's some allegations that China engaged in this as well. And to generally undertake actions that create, maintain, and restore the health of the population. And what's really interesting that in this general comment 14, the CESCR clarified that these obligations actually extend globally. So, a state party like China, for example, has an obligation to respect the right to health also of the global citizenry. So again, just a clearer and clearer breach here, again, assuming the allegations are true. So what can we do about this? Let's go through our 3 options. Human rights treaty bodies. So that's the CESCR. So the CESCR can hear complaints about potential breaches. Can they hear complaints about China? So actually they can't. And that's because international law, as I said, is really based on consent. And the ICESCR, when state parties sign on to the ICESCR, they're basically saying, yes, I agree to be bound by these obligations. But it actually would have taken China also signing on to the optional protocol to the ICESCR, which would have meant that they basically are saying, and I agree that you, the CESCR, can hear complaints about us. So that giving up that is not part of the ICESCR proper. So actually the CESCR can't really do much of anything here. They can put out the usual country report, but we can't complain about China to them. Special rapporteurs, as I said, wait, before I actually move on, that was a really sort of complicated concept. Does anyone have any questions? I feel like I'm seeing some confused faces.
Hey, Sarah. So I have a question that is not in the reference to the slide, but it's in reference to the last slide. I can ask it
Sure.
later if you'd rather.
No, it's okay. Which one?
Okay, well, this maybe is too broad, but address it later if you want. But I'm just curious about, I don't really have a background knowing any of this law, but besides what we're doing this semester, but I'm just curious, like, how liberally can you sort of assess culpability for like a breach on the human right to health? You know what I mean? Like for example, like situations where like the strain that developed in South Africa and was moved to England, and like whether or not these governments did enough to prevent the spread to other countries with their border policies and their trade policies or whatever. Like how, like if we're going to assess that China's culpable, like how liberal can we be in assessing whether these other countries are also culpable?
So I'm really glad you asked that question. So I mean, it's really important to emphasize that me and you, we can look from this is an interesting thought exercise, and we can undertake these sorts of analyses, but we are not qualified to make these determinations. It really has to come down to these sort of international bodies like the CESCR or an international court or tribunal to actually determine culpability. So, what you're saying, yeah, I mean, look at, sub F, to generally undertake actions that create, maintain, and restore the health of the population. So many countries could be culpable under this section. So it's, yeah, I mean, when you're looking at, can they potentially, enough to have these international bodies make this determination, I'd say we can be quite liberal, because then it really falls to these bodies to decide, with some certainty. So that's really important. But another thing to keep in mind when we're looking at other countries, because I have people ask me about the US all the time, right? So, you also have to look at who's a state party. And this leads to some really interesting questions, because the right to health is enshrined in the ICESCR, right? And then the CESCR can clarify that, which means that, there's some debate about this, but a lot of scholars do agree that the state parties to the ICESCR are then bound by these clarifications, because the idea is that they're not making new law, they're just clarifying the existing obligations. But, the right to health is not just in this treaty, it's also a function of customary international law. So the US, for example, is not a state party to the ICESCR. So the right to health, they're still bound by the right to health as custom, assuming they haven't objected. So that would be the first step of an analysis there. Have they objected? Because it's not a jus cogens norm. And then assuming they haven't and they're bound by the SIL right to health, the content of the SIL right to health may be different than the content of the ICESCR right to health. So, you know, these particular, you know, obligations to generally undertake actions, the US may not be bound by this, and the SIL right to health may be a lot narrower, and that would require a lot more research than I've ever done on this issue. So, you know, it's a really interesting question to look at other states' culpability. I'm glad you asked me that. Does that answer your question?
Yes.
Yeah.
I read part of your paper last night, and I was kind of surprised. Maybe we practice different laws. I'm a Peruvian lawyer, and I work for the army. And you're missing the point of view that all crimes against humanity need the will to commit a crime. You can't commit a crime against humanity by, you know, only by because I forgot to close the door, or because I forgot to follow some procedure or something. You need to have the will to kill people, to torture people, or all the other intentions. So you can't find China or to process China to become, you know, like they are going against humanity if they haven't, because they haven't shown the will to do that. You have to prove that they, as a continent, well, as a country, all the Chinese Communist Party, the president or wherever, or China as a whole, decided to kill the rest of the humanity with a disease. If you can't prove they have the will to commit a genocide crime against humanity, you can't process them. You have to prove will. In Spanish, we say dolo. Maybe criminal intention will be the most accurate in English.
You are absolutely right, Nicola, and you're a few slides ahead of me.
Sorry, sorry, Nicola, maybe a better word for that is volition, maybe?
Well, criminal intent is definitely a requirement in the Rome statute.
Volition? Yeah, I don't know.
Yeah, criminal intent is definitely a requirement that I will talk about. I just haven't talked about yet. We're not on that. We're not on the Rome statute yet. And when I was talking generally about the ICC, I was just giving us all the foundation, and this is when I'm really going to dive into these options.
Well, I have to say, I have some examples. Do you remember Haiti?
Haiti. I'm not so familiar with that.
No. So the United Nations sent a mission after they have a civil war, and then they have an earthquake in the 2010, and then they sent a mission from Nepal, and this mission from Nepal didn't have a correct sanitary or sanitation protocol. So all the feces went to the river, and they start a cholera epidemic. So hundreds of thousands of persons died from the earthquake and then from cholera. So when the people make the search, and they found the mission of Nepal was responsible for that, because they have a lack of procedure to make the facilities according to health, sanitation, and regulations. They decided to go against them, and they decided to sue the United Nations, and they couldn't. And international law told that they couldn't. So I am surprised, because even in Peru in the 90s, we have the same case. Chinese ships were fishing near the coast in Peru, and they were leaving all the fishes into the sea, and we eat a lot of fish in the coast. And also we have a break of cholera, and we had like 500,000 of persons infected and almost 2,000 dead. And we couldn't do anything because they didn't have the criminal intention to do that. So according to your analysis, it's very interesting. And really, I would like to know if that has succeeded in other places, because maybe I don't know that example.
Well, we will get to that. That's sort of number 3. You know, the next I'm going to go over the international health regulations, and then we'll go back to the Rome statute. So let's put a pin in that maybe until we get to that slide. All right. So we talked about human rights treaty bodies. The next general option are special rapporteurs. And I've already talked about this. These are international human rights law experts. They're generally always an option. There's one specifically on health. So, you know, anyone can make a complaint to the special rapporteur about COVID. UN Human Rights Council, again, anyone can make a complaint. They can also establish commissions of inquiry. The difficulty here, of course, is China's recent election to the Human Rights Council. So in effect, not really much of an option. We're really just left with maybe the special rapporteurs. Again, these bodies don't have a lot of teeth, so not all that useful in and of itself. Whether or not this was a human rights violation does come into play when we talk about other things like the Rome Statute. Now, the next clear violation is of the international health regulations. This is a WHO document it's a WHO regulation, and it generally binds all WHO member states, including China. Yeah.
Please, Muhammad, Muhammad?
I think I can mute him, or I'll let him mute himself. Okay, great. Thank you. All right, so these are the 4 articles that are, possibly violated here. Article 6 and 7. I'm not actually going to read these out loud, just because that will really harm my already straining voice. So basically, Articles 6 and 7 contain obligations that state parties must communicate to the WHO in a timely manner. Actually, it's within 24 hours of any events occurring within their territory that may constitute a public health emergency of international concern. Article 6 actually incorporates Annex 2 by reference, which contains a handy little flowchart. Literally, it's a flowchart that states can use to see whether or not notification is required. And basically, this just boils down to when events are unusual or unexpected or may have serious public health impact, notification to the WHO is required. And then the state has to continue providing the WHO with relevant information. Article 44 obligates state parties to collaborate with each other in response to these sorts of events. And then Article 46 obligates states to facilitate the transport of diagnostic materials for the public health response. So China is a state party to the IHR. The allegations that China underreported and concealed information, particularly from the WHO, is a violation of Article 6 and 7. The allegation that they withheld information also from other state parties is a violation of Article 44. And then allegations that they withheld live virus samples for weeks would be a further violation of Article 46. So what can we do about this violation? So here we actually look to the treaty text itself. That's pretty common. That's usually the first place you go if there's a breach of a treaty, because often the treaty will itself have an article that deals with dispute resolution. So here that's Article 56. It ends up being not that helpful because none of the enumerated options are compulsory. So basically, in plain English, I know that's a block of text, what this really boils down to is that if there is a complaint against another state party, step 1 is to try to negotiate with that state party. If that fails, step 2 becomes submit a complaint to the Director General of the WHO. And then in addition to all of that, you're permitted to engage in any other international dispute resolution mechanism that might apply, including the Permanent Court of Arbitration. And if there's a complaint against the WHO itself, you can submit a complaint to the Health Assembly. Now, Section 3 here does something really interesting. So the Permanent Court of Arbitration, I wonder if this just happens to be my next slide. No, it does not. So we'll get to the PCA. Wait, where did I go? Sorry. So we'll get to the PCA in more detail later, but basically in a lot of modern treaties, the Permanent Court of Arbitration is incorporated as the compulsory dispute resolution mechanism. So the treaty might say, if there's a dispute, concerning the interpretation of this treaty, states parties agree to be bound by any ruling of the Permanent Court of Arbitration. The IHR does something weird in that it sort of goes halfway. It says here, a state party may at any time declare in writing to the Director General, that's of the WHO, that it accepts the PCA as compulsory. So it gives an option to be compulsory. And obviously, as of at least August, the last time I looked at the website, no state had filed such a declaration. I mean, why would they? So it's a really interesting little element of this. Any questions about this? All right, so now we get into the Rome Statute. So there's 2 challenges with when we're looking at, can we use the ICC for China's concealment of health information, right? So first off, can the concealment of critical health information be a genocide, a war crime, or a crime against humanity? And then the second question is more jurisdictional. Can the ICC take jurisdiction over the case given that China is not a state party to the Rome Statute? I'm actually going to start with that one first. So as I said, China is not a state party to the Rome Statute. Security Council referral is very unlikely given China's veto vote, of course. So, we go back to that Myanmar case that I've already referenced. Basically, any crimes, assuming, again, they can be characterized as a crime against humanity, which we'll talk about next, any crime would need to be framed as having occurred in the territory of a state party. So the Myanmar case, as a possible precedent, it's possible, we could argue that concealment of health information occurred everywhere and anywhere and everywhere all at once. This is, a sort of transboundary global type of phenomenon. It's a global pandemic. Maybe that argument would fly, maybe not. It's a weaker case than deportation, but that's something that could be tried. Now, to here. So can concealment of critical health information be a crime against humanity? So I've narrowed this down to 3 options, and this is a really great place for a class discussion because, these are the 3 that might apply. The crime against humanity of murder, the crime against humanity of extermination, the crime against humanity of other inhumane acts. And I've laid out the required elements of crime here on this slide. For all of them, the conduct must have been committed as part of a widespread or systematic attack against a civilian population. For all of them, any person charged must have known that the conduct was part of a widespread or systematic attack against a civilian population. Now, a separate article of the Rome Statute, Article 2, does say that this doesn't need to be a military attack, so that's something to keep in mind. And then beyond those general requirements, each crime against humanity has additional specific ones. So for murder, the person charged must have killed or caused the death of 1 or more persons. And then each element basically has its mirror image of intent. So, any person charged must have intended to cause the death. And then similarly, the crime against humanity of extermination requires that there was mass killings. And again, the person charged must have known that their conduct would lead to mass killings. And other inhumane acts, there's more requirements because this is sort of a catch-all. Basically, any person charged must have inflicted great suffering or serious injury. The act must have been of a character similar to another crime against humanity in terms of the nature and the gravity. The great suffering must constitute serious violations of established human rights, and that's where the human right to health violation does become relevant to other things. And again, each element has its own requirement of intent. So any eventual foreign official of the CCP would have to have known all of these things. Now, obviously, again, you and I don't have to prove all of these things, but if there's a solid case to be made, then that may be worth a country or a nonprofit pushing the prosecutor's office to open a preliminary examination where she would officially evaluate all of these questions. So this is a really great place to open it up for discussion, I think. What do you guys think about the potential relevance of these 3 articles? Any takers? No one wants to try being a lawyer for 5 minutes?
I have a question.
Yes.
Does the crime against humanity, is that directed like at individuals who are in charge, or is that like the greater CCP? Because I'm just wondering, what's the relationship with the Rome Statute to is that the ICC or the ICJ? I don't remember.
The Rome Statute is the ICC. I'm glad you asked me that. So the ICC, it's individuals, yeah. So it's that's why I keep talking about the person charged, because the allegations could be, could fit a lot of these elements of a crime against humanity. But I think the real challenge when it comes to the ICC is that we'd have to find, or the prosecutor would have to find a foreign official, an individual of the CCP that knew that the conduct was part of a widespread or systematic attack intended to cause deaths or what have you. So the intent element would really be, in my opinion, the roadblock here. But it's fascinating to see that a lot of these elements really could be met. I mean, COVID killed, obviously, lots of people. Concealment of health information that leads to spread of a virus could be considered an attack against a civilian population, and inflicted great suffering in terms of going over to the other inhumane acts. Character similar, just based on the sheer amount of deaths and the amount of loss. It's it seems like it could be of a character similar. It's a violation of the human right to health. It fits a lot of these things, which is really interesting.
Especially if there's we know that certain whistleblowers were jailed. That seems
Yeah.
like maybe it's a stretch, but that seems to me at least like there's obvious intent or thought behind, because otherwise why jail them? So maybe, the information that they had that was perceived to be of that kind of importance that, that seems like an intent to me.
Yeah, no, that's a really, really great point. And the silencing of whistleblowers is something I haven't really talked about, in this presentation so far. So I'm glad you said that. I've been sort of skimming over the facts of the case study just because I really wanted to focus on this law and teaching, using this case study as a way to teach you guys the general framework for how to go about looking at these issues. But, it's really, it's not just concealment of critical health information. Silencing of whistleblowers is a really big part of the allegations as well.
I have a question.
Yes.
Yes, we have another course of international law, and we kind of have an answer for what I'm going to ask, but I wanted to hear from you. In the case, for instance, the Rwanda genocide and other crimes against humanity, when there is when the actor is not a state, neither an individual, is an insurgent group. How does it work? Like to make them pay or be responsible for the actions?
So the official charge, first of all, is Rwanda a state party to the ICC? I don't actually know the answer to that question. Can anyone just tell me?
No, I just put that example, but I mean like.
Okay, well, let's assume that Rwanda is a state party because I just don't know any differently. So yes, I mean, basically, they don't need to, the person who's charged doesn't need to be a government worker, right? It could be any individual that engaged in these crimes. So, the case, I actually worked at the ICC briefly when I was in law school. And the case I worked on, no one that I worked on charging was a member of a government. It was all insurgent groups. These people can be charged, certainly. I wish I had a longer answer for you, but it's really that simple.
Rwanda is not, I just Googled it.
Okay, so in that case, those people probably wouldn't be able to be held accountable unless there's a Security Council referral or some type of creative solution. But, assuming the genocide happened squarely within the borders of Rwanda, I'm not sure there would be a creative solution like there was in Myanmar. Interestingly, Myanmar is being used presently as a way to try to get the Uyghur genocide in before the court. And that's, maybe that's sort of analogous because that happened pretty purely again within China. But the argument there is that, like I sort of talked about getting a mafioso on tax evasion, like the Uyghur people before they were, before the genocide, happened for some of them in the territory of China, they were forcibly transferred from Tajikistan and or Cambodia into China. So what's happening now before the ICC is a group of lawyers is trying to get that case before the court via, again, deportation and forcible transfer. So that is currently happening. Actually, the prosecutor releases yearly reports on how they're doing in terms of preliminary examination. So this one came out actually just like a week ago, because this is pretty new. But basically what happened is the prosecutor said that they don't have enough information to proceed with the Uyghurs right now, and they asked for further information. So that's where it is in process. And what's interesting is that, there's other requirements when we're talking about forcible transfer. It's sort of beyond the scope of this lecture, but basically the people who were forcibly transferred, if they were transferred from Cambodia, say, to China, they would need to have had lawful status in Cambodia, whether, it could be as a refugee, but they need to have been there lawfully. And then the Chinese government or the Chinese official charged or whatever, someone needs to have had a hand in forcibly transferring them back to China. So there's all sorts of jurisdictional requirements. And from my understanding, that's actually what was missing. It was the prosecutor wanted more information on their status in Cambodia and or Tajikistan. That's an interesting sort of news in international criminal law. All right, maybe I'll move on. So we've already talked about this. So basically, the conclusion about the ICC is that it's possible, it's not a clear-cut violation like the right to health or the IHR, but it's a really interesting thought exercise and something we should definitely keep in mind as more information comes to light. Next is the biological, yeah? Was that someone or someone muted themselves? All right, so the Biological Weapons Convention. Article 1 requires state parties to never develop, produce, retain biological agents. Biological agent just means any organism, either natural or genetically modified, which can cause death, disease, and/or incapacity. So you see right away that, you know, a disease like COVID could be a biological agent. It's a pretty wide definition. And this is a definition not actually from the language of the convention itself, but from a meeting, an ad hoc meeting of state parties that's published by the UN. So it's a fairly official definition. Article 3 prohibits state parties from transferring directly or indirectly any such biological agent. Article 4 requires state parties to take any necessary measures to prevent this sort of thing. And Article 5 requires state parties to consult one another and cooperate. So China is a state party to this convention. You could see here, it's, you know, you can argue pretty compellingly, I believe, that it's a breach of Articles 3 through 5. By not shutting the borders, this was effectively an indirect transfer to other state parties of a biological agent. This is probably one of those conventions that can be used also fairly easily to look at other countries' culpability, because it's so sort of simple and, you know, contained, and not closing borders could be an indirect transfer. So, you know, this is going beyond like silencing whistleblowers. A lot of countries may have failed in this.
I have a question.
Again, yeah.
All these conventions were, you know, signed and ratified like a long time ago. Have you heard about the patient zero of ITB?
Patient zero. I don't believe we know about patient zero yet, unless I'm.
Patient zero was when the AIDS epidemic started in the United States and British. I know, probably you weren't born. This started in the 80s and the 90s, well, mostly 80s, and a lot of people died before the retrovirals started. So guess where the patient zero was from? Canadian. So according to these violations of the biological protocol, every country that has suffered people dead by HIV could sue Canada because the patient zero was from there.
Maybe. I mean, like, I don't think that would happen.
Why? Because the violations are there, and he was the one where everyone spread. Yeah, they say about something about Africa, monkeys, and whatever, but the patient zero was in '84 in Canada. He was Canadian. So from there, well, he was the older one, patient zero name, very famous. And according to that, you know, we spent as a country in Peru a lot of money putting retrovirals, and now we have 1 million persons from Venezuela and almost 50,000, and all people that have AIDS, now refugees or economic migrants in Peru, they have access to these retrovirals, and we don't have enough for our population. So we have a lot of money to put and you know, medicines from this, because part of all the treaties on human rights we have signed. So according to this protocol, we can sue Canada and ask Canada to pay for all the medical bills of these people that have HIV.
So I'm glad you actually phrased it that way, because that is an important clarification I want to tell you all. This does not, you can't sue a state based on the Biological Weapons Convention. There's very limited ways in which you can sue a state civilly.
The same for China.
Yeah, well, you can't, this doesn't enable civil lawsuits. This is a totally different thing. The Biological Weapons Convention really just enables countries to complain to the Security Council. That's it. It doesn't, you can't sue civilly in domestic courts based on this. That's really important for you guys to understand. So really, I mean, again, this is something that doesn't necessarily then have a lot of teeth, especially for a country like China, which has a veto vote on the Security Council. Okay, let's move on to the ICJ and the PCA. The International Court of Justice, I've already talked about this actually, it's the principal judicial organ of the United Nations. They can't make binding rulings without consent, but you can seek an advisory opinion without consent. So this is sort of just always an option. The UN General Assembly or one of the other bodies that's entitled to do this can ask the ICJ for an advisory opinion on, you know, these types of questions that you and I can't really, you know, answer with the authority of an international body, right? Like they can ask the ICJ about how this was a violation of various international treaties. The Permanent Court of Arbitration, again, I've already talked about this too. It's often incorporated into modern treaties as a compulsory dispute resolution mechanism That's not the case here. It was not incorporated into any of our treaties. It's not available for the right to health. It wasn't available for the IHR. At least no one filed that written declaration I talked about. It's not part of the Biological Weapons Convention. So this is something you always want to look at, but more in reference to the other treaties, because it's highly unlikely a country like China especially would give their consent for the PCA to make a binding ruling. Any questions here? All right, let's move on to the World Trade Organization. Now, this is something I always like to look at, when a client will ask me, hey, Sarah, what do we do about X? Because the WTO dispute resolution mechanism is highly active. It's very efficient. I mean, currently it's in crisis actually because of President Trump's refusal to appoint or reappoint to the appellate body. But in general, it's a really good avenue of recourse. And generally speaking, any member state can bring a dispute if they believe another member state is violating an agreement or commitment that it's made in the WTO. China is a WTO member state. So the question really to ask here is, can Chinese government actions be framed as trade related? And my answer, if you've read this part of my paper, is yes. Generally speaking, the way that public health and trade interact is fairly intricate. It's the subject of a very long co-published between WTO and WHO report that was published 20 years ago. It's only become more integrated. And basically what this really boils down to is that countries, or WTO member states, I should say, are allowed to impose public health measures so long as they don't unnecessarily restrain trade. That's the quote, unnecessarily restrain trade. So basically, to use the WTO here, my idea was that you basically make the inverse of that argument. And you say, well, Chinese concealment of health information for multiple weeks effectively forced other states to impose these stringent lockdown measures, shutdowns, what have you, that unnecessarily restrain trade. So it's sort of the mirror image of the usual argument, but it could work. And also the WTO has a history of being pretty flexible when they're looking at jurisdiction. They looked at a dispute involving Qatar that was only sort of tangentially trade related. So they tend to be flexible here. So that could work to use the WTO. And then the WTO has the power to invoke or impose trade sanctions. So it has more teeth than some of these other mechanisms.
They have respected now the 8 hours turn, because last time I checked, China doesn't follow 8 hours a day, 48 a week, and they don't have a month for vacation and a lot of rights. And that is why they joined the World Trade Organization, because he wanted to sell things to the rest of the world, but he put a restraint about a lot of human rights on their population. Maybe they have signed it these days, and I'm not aware of that.
I'm not sure what you mean by 8 hours.
I don't know. It's not in Canada also that you can only have work 8 hours a day?
Oh, you're talking about, oh, I see. You're talking about employment law now.
But China joined the World Trade Organization, but they put a restraint about 8 hours a day, 48 a week, not a month of vacation, and a lot of that stuff. That's why they are part. So they have a lot of restriction. And if they have all these restrictions, I hardly believe you could sue them by this organization.
I don't know a lot about the things that you've just mentioned, but again, I do want to emphasize that this is not like suing China in domestic court. This is a contained possible option, avenue of recourse to go through the WTO dispute settlement body. All right, domestic solutions. So first I'm going to talk about imposing sanctions, and I'm going to talk only about Canada and the US here because that's my area of expertise. So these are the 2 acts that enable Canada to impose sanctions on foreign states. Special Economic Measures Act, as I've already talked about, allows Canada to impose sanctions if an international organization of which Canada is a member, such as the UN, makes this kind of request. They can also impose sanctions if there's been a grave breach of international peace and security that has resulted in or is likely to result in a serious international crisis. They can also do this for gross and systemic human rights violations. And gross and systemic refers to basically timing, quality, and quantity. Last option is if there's been significant corruption. And you only need one of these 4 circumstances to be clear. The US IEEPA allows sanctions when the president has declared a national emergency and it's an unusual and extraordinary threat. So that's fairly simple. In the case of COVID, I mean, there's an argument to be made for basically 2 through 4. You know, you may be able to prove that this was related to corruption, that, you know, this is a grave breach of international peace and security, and it has resulted in a serious international crisis. In terms of human rights violations, as we've talked about, it's a violation of the right to health. The difficulty here would be whether it was gross and systemic. And I think that's really up for some debate because, you know, timing, we have to look at timing, quality, and quantity. Timing has been, timing is the least important when you talk about these 3. That's pretty settled. So it is mostly about quality and quantity, which could be satisfied here, but timing is still a factor. And this wasn't, I mean, this is a new thing as of 2020, unless again, you argue that China did this for SARS as well back in the early 2000s. So there's an argument to be made for number 3. My personal opinion is it's a little less strong as compared to 2 and 4, and you only need 1. Any questions here? All right. There's also legislation that allows countries to impose sanctions against foreign officials. And here we're going to talk about the Magnitsky Acts. There's one in Canada, the US, as I said, the EU, the UK. I've only personally read the legislation in Canada and the US, so I'm not going to speak to the versions in the EU and the UK. Again, I'm not going to read this whole slide. Basically, what this boils down to in plain English is that foreign officials can be sanctioned if they've engaged in 1, extrajudicial killings, 2, torture, 3, other gross violations of human rights committed against whistleblowers and or human rights defenders, and 4, corruption. And that's a different run through 4 than they have here, but that's my 1 through 4. So can concealment of health information, can this be sanctioned? I mean, it's, again, you could potentially categorize it as a corruption, or it could maybe be another gross violation of human rights against whistleblowers or human rights defenders. The more compelling case is the silencing of whistleblowers. It'd be very easy to sanction foreign officials who engaged in the silencing of medical whistleblowers under the Magnitsky Act. When it comes to pure concealment of critical health information, this may or may not be sanctionable under Magnitsky. But to be clear, you don't sanction specific acts, you sanction foreign officials. So, you know, if a foreign official did both, that foreign official could be sanctioned. Does that make sense? Okay. Now we're going to talk about civil lawsuits against China. Nicole, I feel like you're going to enjoy this one now. So basically, the rule here, as I said, is that states cannot be sued. Generally, we have the general rule of sovereign immunity. So basically, to get around that, one of the existing exceptions needs to apply. Now, there's actually a bunch of civil lawsuits currently filed against China in US domestic courts. And they have cited these 3 most commonly cited exceptions: personal injury, commercial activity, and terrorism. So I'm going to go through them really quickly and just give my 2 cents on whether or not I think this is a good case. Basically, spoiler alert, I think that it's not. When it comes to personal injury, as I said, back to the example of me being tortured by Iran. If Iran tortures me in Canada, great, I can sue them. If they torture me in Iran, I cannot sue them. So when it comes to COVID, you know, concealment of health information, silencing whistleblowers, you know, that happened in China. And you can maybe make the same argument I briefly referenced when we talked about the ICC. Maybe you can say, well, this is a trend, like this is a, you know, borderless global type phenomenon. Really, concealment of health information occurred everywhere, anywhere and everywhere all at once. But the difference between here and the ICC is that the ICC has been pretty liberal in terms of interpreting jurisdiction, whereas Canadian and US courts both have been very restrictive when it comes to analyzing personal injury. So
can I say something, please?
Sure.
Now, states cannot be sued by individuals due to sovereign immunity, but they can be sued by other states. I mean, a state can sue a state, but I cannot sue a state as an individual due to sovereign immunity.
Sovereign immunity when
we released in Canada, but in the rest of the world, yes, you can. We have an international court for Latin America, the Costa Rica. So we have American. Also, Canada is part of it, and yes, we can put civil lawsuits against the countries.
No, but what I'm trying to say is that individuals, in their capacity as individuals, they cannot sue a state.
Yes, you can.
That's understandable.
Yes, you can. Yes, you can. For us, in the Inter-American Court, we can.
All right, you guys,
Well,
let me
that's
just finish this slide and then we'll open it back up to discussion, all right? Because
okay.
there's a lot more to cover and I think I may actually end up answering some of your questions. But basically, I mean, I'm talking very limitedly about Canada and the US civil courts, whether or not foreign states can be sued in those courts. And the rule is that they cannot. I don't know, I'm not an expert in regional courts in Latin America or the system in other states, but I'm telling
Canada is part of America.
Okay,
Oh, it
I'm
is?
speaking about Canada and the United States. These separate countries, separate rules, but I'm familiar with both of them. And in both of them, foreign states cannot be sued unless it falls under one of the limited exceptions to sovereign immunity. That is what I'm telling you. Again, I don't know about regional courts in Latin America. Obviously, this doesn't apply to international courts. I'm talking specifically about domestic Canadian and US courts, all right? But we can open this up for more discussion a little later. So basically, as I said, personal injury, unlikely to apply in the case of China's concealment of critical health data. Commercial activity, also very unlikely to apply. It's, when you're looking at whether or not an act is commercial, you generally look at the nature of the transaction. In the case of concealment of health information, silencing of whistleblowers, et cetera, it's hard to even really define what the transaction is. I suppose it could be a failure to regulate the wet market. That's the closest to commercial I could come up with in my research. And even that's not commercial, it's regulatory. So again, don't think that would apply. Terrorism, again, wouldn't apply. The terrorism exception is actually where Canada and the US rules differ. They don't in the other two. So, or maybe a little bit in the nuances of commercial activity, but that's not really even worth getting into here. So when we're talking about terrorism, to get around sovereign immunity in a Canadian court for terrorism, the foreign state has to be listed as a state supporter of terrorism in the regulations. The only two states listed as of now are Iran and Syria. So right away, that wouldn't work in Canadian courts. In the US exception of terrorism, the foreign state doesn't have to be listed, but the definition of terrorism is quite narrow, and concealment of health information, silencing of whistleblowers would not fit this definition. So basically what we're left with is the US and or Canada would have to pass a law to add another existing exception to sovereign immunity, which actually is also in process in the US. There's an act called the Stop COVID Act put out by Senator Marsha Blackburn and others, which would basically establish a new exception specifically for COVID. Criminal prosecutions, universal jurisdiction. I already talked a little bit about this. Basically, the ICC is not the only body that can prosecute for genocide, war crimes, or crimes against humanity. Domestic courts can as well, pursuant to this principle of universal jurisdiction. However, the relevant official would really have to visit, and this is complicated by personal immunity because heads of state, ministers of foreign affairs, ambassadors, diplomats, none of these people can be sued until they give up their position. So it's an option in theory, and so it's important to go through it as part of this case study, but it's not really something we can do right now in all probability. Now, as I said, novel legislation is something to consider usually at the end of this type of analysis. And I've already talked now a little bit about a new exception to sovereign immunity and the one that's in process in the United States. When we're looking at that, the thing to keep in mind here is the reason a lot of politicians like this is because it can lead to concrete results. As I said at the very beginning of this presentation, if a domestic court in the US finds that China was culpable for breach of law, then Chinese assets in the US can be seized, sold, and the proceeds can be distributed to victims. So this has tangible results, unlike a lot of the international options I gave out already. The difficulty is you have to assume that the country is going to pass a similar legislation. International law is based on consent and also to a large extent anyway, and it's also based on reciprocity. So if the US passes the Stop COVID Act, the US can expect that China will pass a similar act and sue the US in their domestic courts. So, this really, what I'm hoping that politicians are now doing in the US is looking at both the value of Chinese assets in the US as compared to the value of US assets in China. Because you have to assume if you can seize Chinese assets in the US, China can seize US assets in China. And if the value of US assets in China is greater, then in effect, you're not doing the victims much service. Another option for novel legislation is, as I've I think I've briefly referenced this already also, is expanding the Magnitsky Act. So the Magnitsky Act as it stands now can pretty easily allow for the sanctioning of foreign officials who engaged in the silencing of whistleblowers. But if some foreign officials didn't engage in that and only engaged in the concealment of health information, it's unlikely that they could be sanctioned. Now, maybe that's okay, maybe it's enough. But you know, another proposal I've personally even seen floating around is to allow for sanctioning those types of foreign officials. There was a proposal out of the Hudson Institute early this spring that basically said, let's make a new act to allow for this sort of sanctioning and call it the Dr. Li Wenliang Act after the medical whistleblower who was silenced and then tragically passed away from COVID-19 in, I believe it was February. So that's another option as well. We can have a new act to allow for sanctioning of people who just engage in the concealment of health information, or we can expand the Magnitsky Act. It would have the same effect. Now, lastly, is domestic lawsuits and prosecutions in China itself. Now, obviously, domestic levels of corruption in China probably effectively preclude this as a possibility, but it's really interesting to note that concealment of health information and irresponsibility when it comes to pandemics is a breach of China's own laws as well. I've outlined a bunch of articles that are relevant. I'm not going to read them out loud. Again, you'll have these slides. Most importantly, in my mind, is Article 409, breaches of China's criminal code, which criminalizes government work personnel whose serious irresponsibility has resulted in the communication and spread of infectious diseases. So back to my conclusion slide. Basically, I mean, this is what it comes down to when you're looking at any question of what an international breach. The first thing you have to look at is this the breach of any law? You look at the treaties, you look at customary international law, as I've said, and you find out if this is actually a breach of anything. And then step two becomes, okay, well, what can we do about that? So as I've said, you look to the text of the treaty, we did that, and then you go through a general checklist. If one of the human rights instruments is potentially breached, then human rights bodies are going to be applicable. You also want to look at whether or not you can use the International Criminal Court, the International Court of Justice, the Permanent Court of Arbitration. Is that in any of the treaties? Can you use the World Trade Organization? Because as I said, that's a really effective and efficient one. Can you impose sanctions in the domestic country in which you're situated? Can you use domestic courts to sue in civil court and or prosecute criminally pursuant to universal jurisdiction? And if there's nothing you could do, or if what you can do is not quite enough, you can always look at novel legislation. If the law isn't good enough to address a certain crime, then make a new one, right? So that's it. So now let's open it up for further discussion. Anyone have any questions or comments?
Can I ask a question?
Yes.
Thanks for your lecturing. I find you have a precondition. Do you think China did conceal the epidemic at the beginning, or just an assumption? This statement, I know, comes from some media or country don't like China, such as US or Canada, but WHO never recognized that, and for now we don't have proof for that, even different source of corona. I just want to know that.
It's a good question. I'm glad someone asked that question. So like I've said, I think a couple times, I am not a qualified international body that can make findings of fact. So I am working off certain assumptions and using media accounts, but also really accounts of whistleblowers. And that's what I'm basing it off of. But yes, I mean, this whole presentation is really premised on assuming the allegations are true, what can we do about it? Because this is a really interesting case study in terms of to learn something about international law. But yeah, it's for sure if the allegations are true, of course.
Thank you.
Can I ask something? Hey guys, congratulations. Was like a lot of information new and great the analysis that you did. Okay, open also windows, you know, for us to think. So Miri, I guess you said that you also we're gonna touch something related to Iran.
Was that a question for Miri?
Miri.
Miri said I would also talk about Iran.
No,
yeah, I mean,
or what's your intention? Sorry, you didn't talk about Iran now, but do you have to say something like in connection with your presentation related to Iran and something similar? Yeah.
Yeah, good question. So that tells me that you read my publication, which I love. So in my publication, I did talk about China and Iran. It was just a broader case study than what I presented today. I chose to focus on China today because of, well, time constraints, and also the major case is of course against China. Iran was more like supplementary, just to widen the written case study beyond just one country. And the reason I did that in the written case study was because the allegations against Iran, and again, just allegations, are very similar. They're very similar. It's concealment of health information and silencing of whistleblowers, basically. So it was useful to put them together.
But the position of the power position of China is not the same as Iran. I mean, in the war, yeah.
Exactly, and also it's started in China, not Iran. So it made sense here, limited by time, to really focus in on China.
Chelsea put a question in the chat, or that she wants to ask a question.
Oh, I don't have the chat open anymore. What happened? I thought I had it.
You can click more. Also, you can unshare your screen and then you can see everyone all at once there.
Yeah,
that's true. I'll do that.
A short question from your paper that surprised me also a lot. You can't sue a country and take all the profits or money or the national budget of a country to pay indemnization. Is forbidden, and I haven't heard of a case. Well,
Nicola, I'm gonna come back to you because you've had the opportunity to ask a lot of questions, and I'd like to hear from Chelsea.
Okay, I was just gonna ask about the Uyghur genocide, which you kind of touched on. So I guess I was curious, I've done a lot of research on this, but can you explain, like, if there are so many human rights violations and violations of international law in the genocide, then how is it still going on? And like, why hasn't it been brought to any form of international court? And like, just touching on the barriers, I know we kind of touched on that with China's veto power as being part of the Security Council, but yeah.
Yeah, I mean, that's really what it comes down to. It's, when you go through, actually, let me share my screen again, because this will be useful too. How do I do that? All right. So yeah, this is a really interesting next case study, and actually what I'm writing next. Oh, where did it go? I should know how to do this more. Hold on. Yeah, I mean, this is going to be my next publication, so look out for that. But basically, when you look at international human rights treaties, they just, let me go through this. They don't have a lot of teeth, right? It's naming and shaming. When you look at it, it's obviously the IHR is not relevant. When you look at the ICC, I mean, I'd already talked about this a little bit, but there is a case that's trying to get before the ICC. There hasn't been much luck. I suspect that whether or not it proceeds may have something to do also with who is elected as the next prosecutor. That's currently underway. So we'll see where that goes. I mean, the thing is also with the ICC, even if it gets to the ICC, genocide may not be able to be looked at, right? It may just be the forcible transfer. So that's limited. The ICJ requires consent of states, so China would never consent to this. Oh, actually, something that I'm looking at right now that I just totally forgot about temporarily is that the ICJ is referenced in the UN Genocide Convention. So there may actually be a way to get that without consent. Again, stay tuned for my next analysis. Sanctions, the US has imposed sanctions on Chinese officials who are involved in this genocide. So that's something. I mean, I'm involved in a few nonprofits that are currently pushing Canada to list them under Magnitsky. Civil lawsuits, nothing applies here. Criminal prosecutions, officials would have to visit. Novel legislation has also already been passed in the US. There's an interesting one I'm also involved with that's in process in Canada that would deal with importing goods from China. And because there's also forced labor there, right? That's one of the many human rights abuses, as I'm sure you know. So there's a bill, I think it's called S204, that I've been helping push with nonprofits here that would basically deem goods that arrive from that part of China as slave labor, and the company would have the onus to prove that they weren't produced with slave labor in order to get them imported into Canada. So there's some things that are ongoing. It's difficult, of course, with China's position, but there's things in process.
Mm-hmm.
Does that answer your question?
Like mostly. So like, I guess it kind of is because of like the non-binding nature in part, and then also like China's veto power. I'm just trying to like understand. And then also, so like the only way to really get it would be through the ICJ, you said, or was it the ICC?
Probably the ICJ, maybe the ICC. It's still pretty early. I mean, unfortunately, a lot of these, these international law recourses, it's hard to get them at the same, like contemporaneously. Like a lot of this is justice after the fact, which is a whole other problem. So it's, it's tough. Like, but things are in process. So I'm hoping that that states will start to do something about this. I mean, they are already. It's just kind of late to the game.
Okay, thank you.
Yeah, you're welcome. Any other questions, or we can go back to Nicola if everyone else has had an opportunity. All right, Nicola, why don't you ask your question again? Remind me what you'd asked.
I asked that you can put an embargo on another country. That will be looting. That will be like the US paying themselves the war taxes, invading Iraq and selling all the archaeological items they found in the museum through eBay. You can't sue a government and put a restriction and pay you the civil laws with a conflict. In your example, in your paper, you say, yeah, you can go against a country and ask to pay back. No, you can't. You can ask individual indemnizations of specific stuff, but you can't embark all the country money budget, national budget for education, health, and whatever to pay indemnization.
To be honest, I'm not sure if you're asking me about sanctions or about civil lawsuits or about
That's what you put
recent
in your paper.
CBSA bill. I just, I put lots of things in my paper. I'm just not sure what you're referring to specifically here. Are you talking about special economic measures, countrywide sanctions?
Well, you can't ask for individual indemnization, but only an individual or a group that has been harmed. But it's very difficult. Maybe you don't remember the Vietnam War, but the US spilled and threw a lot of orange agent over the leaves of the jungle in Vietnam to avoid the North Korean guerrillas people. So after 3 generations, the people that was there, they still have cancer problems. And they tried to sue the United States to ask to pay for health bills and indemnization, because after 3 generations, they still have people being dead and have with congenital diseases due to this orange agent. And they couldn't. And it's proof. They have how they know that it was a orange agent. They know how was the amount of this chemical they throw over there. And they have all the information, and they couldn't. The US only says that have this money, these pennies to pay for the coffins, nothing more. So I haven't heard that any other country, or as you say, part of the Security Council has been sued for that. It will be very difficult. And the only embargo I know is the one the United States has in Cuba. And the embargo is not to take United States capital to Cuba, not that they have cut all the money from Cuba. Well, according to your paper, but maybe I read it wrong.
Yeah, I mean, honestly, I never used the word embargo. I talked about sanctions. I talked about civil lawsuits. Maybe you should give it another glance. Now, on that note, it has been an hour and a half, and I know that I was supposed to speak and answer questions for an hour and a half. So cognizant of the fact that you guys may have another class to run to, I think I'll hand it back unless anyone has any further questions to Miri.
No, interesting. Thanks.
Thank you.
Thank you so much, Sarah. I think we all really got a lot of insight and maybe just no one has questions. I think we're all just stunned by your wisdom, and we have lots to think about. And I'll pass along the slideshow to everyone in the class so you guys can all take another look. And if anyone wants to reach out to Sarah, you can ask me, and I can potentially pass on any questions or give out her email if you have a particular question for her. Otherwise, thank you so much for being here, Sarah.
Yeah, you're welcome. I was going to say also, I'll give you guys my work email via Miriam if you have any questions, or if anyone's interested in law school and wants some advice on that. I mean, I'm around, I'm available. I love taking on new mentees, so don't be shy.
Thank you.
Thanks. Bye.
Bye.
Ciao.